All right. Hello, everyone. Welcome to our webinar. I'm sorry. Welcome to our April webinar, Time Flu. I am Cassandra Theogene, and I am the Executive Assistant for BIAD. I will be your host for today's presentation. Today's topic is legal aspects of brain injury, presented by Attorney Wade Scott from the Delaware Elder Law. Before we get started, I do have a few housekeeping rules just to remind you and some reminders for you. The chat box is located at the bottom of your screen. Click the chat cloud icon to open up that feature. Any questions you should have, please enter them in the chat box. We will be sure to take some time at the end of the webinar and answer as many questions as we can. When the presentation should begin, we will place everyone on mute so that all the information can be cohesively presented. And lastly, all materials from the webinar will be followed up in an email. Before we get started, I'm sorry, we just had a participant come in. Hello, love. All right. So this is today's webinar. Our speakers. Letting some people in. All right. Now, before I get started, I'd like to thank today's series sponsor, Blueprints for the Community, Highmark. We truly appreciate your support. Highmark Blue Cross Blue Shield Delaware was pleased to award us with $10,000 in a grant for Blueprints for Community. Blueprints for the Community, the donor advised fund of Highmark Blue Cross Blue Shield Delaware at Delaware Community Foundation has contributed over $21 million to the community since its inception in 2007. It was established to serve Delawareans with an emphasis, but not limited to those to those in need, uninsured, and underserved, to reduce healthcare disparities in minority populations and address social determinants of health. Learn more at www.highmark.com/blueprints. I would like to introduce our speaker today, Wade Scott. Delaware's attorney, Wade Scott, earned his law degree from George Mason University Law School in 1984. His estate planning credentials from Temple University Beasley School of Law in 2007. Wade is a member of Wealth Council, Elder Council, and the National Association of Elder Law Attorneys, and has been voted to the 10 best elder law attorneys for the past 2 years, as well as one of Delaware Today's top 10 lawyers in 2021. The Delaware Elder Law Center helps families who become overwhelmed with caring for disabled loved ones. The office supports the caregivers, helps put care in place, and creates a fund to pay for the care. Without further ado, I present to you guys Mr. Wade Scott.
Thanks, Cassandra, and thanks, Cheryl, for you all having me on today. And during my presentation, as anyone has questions, please ask them as they arise. I guess technically the thing to do is just raise your hand. And so my reference point for today is to talk about what are some of the legal issues and practical issues that arise when someone has a brain injury and they get through the immediate process and they're going forward with their lives. The very first big issue that comes up is, does the survivor have their disability documents in place? And that's my term. It's a group of documents that a lot of you are familiar with, and they consist of the durable general power of attorney. That's the financial authority The Advanced Healthcare Directive, a lot of you may know that as the living will, and then the HIPAA release. These documents together are what I call the disability documents. And as you're going to learn in a little bit, those documents are found in a person's estate plan. They just might actually realize it. And so where these disability documents come into play and why it's one of the first things that comes to mind is if a person suffers a brain injury and it results in their inability to make financial or healthcare decisions temporarily or even on a permanent basis, then the question is, has that person empowered someone to make financial and healthcare decisions for them? And that's done by putting in place these documents. And so from a legal point of view, if a person has not signed these documents, then no one has authority to make decisions for them if that's what needs to be done. It's important to understand that your family status is like husband, wife, brother, sister, parents. If the survivor is an adult and these documents aren't in place, no one has authority to make decisions for them, and they're going to run into just a huge roadblock. And so it becomes really important to get the documents in place before any crisis actually takes place. And as I said earlier, these 3 disability documents are part of a person's estate plan. And so in the ideal world, it's best to get your basic foundational estate plan in place while you're still able to, while you're still in control of it. But let's just talk about, well, what happens if I don't have these documents in place? I do get hurt and I can't make my own decisions. There is a backup plan, and that is the guardianship process through the court system. That's where one of your loved ones typically would petition the court to become your guardian, because there's no legal authority naming someone to have this power to help you make decisions and carry them out. So the authority to make financial decisions, the authority to make healthcare decisions would come from this court process. It comes from the judge in the form of a written court order saying that a certain person is the guardian and they have the following sets of authority. It's just that the guardian process is stressful, it's expensive, and you as the person that's going to be under the jurisdiction of the court didn't have a chance to give your vote as to who that person is that's going to be helping you and what they can do for you. You know, you're just inviting the court in to provide those pieces of authority. The durable power of attorney in Delaware is a separate document from the Advanced Healthcare Directive. So in Delaware, you have 2 different documents. Some states, they merge the 2 documents. It's just important to understand in Delaware, there's 2 separate documents for that. And the durable power of attorney empowers someone to make financial decisions and business decisions. And the Advanced Healthcare Directive names the healthcare agent, but it also puts in writing well, let me put it a different way. That Advanced Healthcare Directive does give you the opportunity to put in writing what end-of-life decisions and measures you want or don't want if you find yourself in the future in two medical conditions. One is permanently unconscious, which is brain dead, and the other one is end-stage terminal illness, where there's nothing more the doctor can do. So you can elect in writing to say that you do or do not want basic life-sustaining treatment. And then in addition to those two documents is a HIPAA release, and that's a written document naming who can speak to the doctor and who the doctor has authority to speak with and share documents with. So those are the disability documents. That's the first thing that comes to anyone's mind when a person is injured and they have a period of time where they can't act for themselves. You know, they need an advocate. As I mentioned, these disability documents usually are created during the estate planning process. And when you say estate planning, most people think of putting a will in place, but it's more than just that. It also includes addressing the issues of disability. Sometimes I'll have clients say, well, I don't have anything. You know, I'm not rich. I don't have a lot of assets. But estate planning is really not just for people that have assets or the wealthy. All of us have an estate. You own the clothes on your back. You have tangible personal property that belongs to you. A lot of people own a house. They have a basic checking savings account, and some people have IRAs and that type of thing, and there should be a plan for those assets. And you want to put the plan in place before the crisis, so that you get a vote, you control it, and you can get in writing what your intent is. And the will doesn't need to be complicated. You just need to address the various types of property that you have, who are the beneficiaries, and what amount should they share in your assets. And really importantly, who is it that's going to be in charge of the process when you pass? You want to pick that person, right? And you need to, well, it's best to also name a backup for that person, just in case when the time comes to serve, if they're not available, then what? You want a backup name. That way you don't have to go to court and petition the court to have a certain person empowered to be the executor of the estate. And actually, Cheryl raised a really good question when we were just talking before we began taping, and that is, could I clarify the basis for authority for a disabled person during their life, and then at death, who has authority to address all the issues that come up because of death and have access to assets and settle the estate? So during life, if you're a disabled person in the sense you can't make your own decisions, it's the power of attorney that gives someone the authority and responsibility to act in your best interest and make financial decisions and carry them out. But when a person dies, their power of attorney expires immediately. So as soon as a person dies, their power of attorney is null and void. And whoever their power of attorney was doesn't have any authority to go forward unless in the will that person is named as the executor, and the executor petitions the Register of Wills to have their authority activated. And the Register of Wills issues a piece of paper we call a short certificate that sets out the authority that the person has to settle the estate and have access to the assets. So that's kind of the process in the background. During life, it's the power of attorney making decisions that need to be made. At death, then it's the will that names the executor, and that person has authority to take action to wrap up a person's estate and have access to their assets. So I think you can begin to see why this documentation is really important in the context of an individual suffering a brain injury and going forward in their life. If they need support, then these documents are really, really important. Another question that I'm often asked about what brain injury, what legal issues brain injury can trigger. And one of them is from the point of view of a parent who has a child that survived a brain injury, and that child requires assistance for activities of daily living. So there's a healthcare aid involved, and Medicaid is paying for that. So to get that in place, the surviving child needs to apply for Medicaid, be approved, so that Medicaid will pay for the caregiver, and there will always be money in place. Well, what happens if the parent dies and wants the surviving child to inherit assets? The concern is, well, if they inherit assets, they'll lose their government benefit known as long-term care Medicaid, and it'd be the same for Social Security, supplemental income. There's some financial requirements for that. And what the parent thinks is, well, I can't have them inherit directly, so I'm going to give their share to their older brother, and older brother will pay for whatever that person needs. Usually that's a bad arrangement. And another way to go about it, and it's probably the better way, is to put in place in your will what we call a supplemental needs trust, so that the survivor of the brain injury inherits their share, but it goes into a supplemental needs trust that's managed for their benefit, and that money's in place to cover out-of-pocket expenses, and they don't lose their government benefit. So that's a real powerful piece of planning, and it takes a lot of pressure off the concerned parent. And I'm just using the older sibling as the example. The older sibling won't have the pressure of, am I doing the right thing or not? Am I doing what mom and dad wanted? And once people understand that, they find it to be helpful. So I'll also just mention, so that you begin to have a foundation of information. And so I'm talking in the context, not necessarily of someone that's, survived a brain injury and needs support from others, but anyone that has a medical condition that's made it so they need assistance with activities of daily living. That's going to be provided by a caregiver, either in the home or in assisted living, skilled nursing. That type of care is expensive. And most people can pay that expense out of their pocket for only a short period of time. Then if they run out of money, who's going to pay for it? And that's where long-term care Medicaid comes in. The important point I want to make is that long-term care Medicaid is a government benefit for the medically disabled, not the indigent. Now, there's multiple Medicaid programs. Some of them are for people that don't have any assets. And some are for people that are medically disabled in the sense they need assistance with activities of daily living. That's what long-term care Medicaid is about. It's for the disabled because that's the mandatory requirement. If you're not disabled, well, you'll never qualify for long-term care Medicaid. If you are disabled, yes, there are some financial restrictions. And there's rules about how you meet those restrictions. Now, the rule that you know about is the general rule. And let's just talk about an individual applicant. The general rule says, well, that applicant can only have $2,000 in assets. If they have more than that, they need to spend them down. That's the buzz term. Spend down just means to consume those dollars until they're down to $2,000 or less. And the general rule anticipates you'll do that by paying your bills and paying for the caregiver. There are exceptions to the general rule. And the point I'm trying to make is that for people who have assets, they own a home, they may have an IRA, checking and savings, maybe they have a US savings bond. Individuals that have more than $2,000 can qualify for long-term care Medicaid without having to consume the dollars down to $2,000. The exception to the rule makes it so that the individual can protect up to 50% of their assets and qualify for Medicaid. And that's what we help people do. And so the only point that I'm trying to make is if a person needs assistance with activities of daily living, there is this process that allows them to get the care they need in place early before they've run out of money. And they get to protect some of that money so that their money is stretched out and they have the care they need, and Medicaid's paying the big cost for that. That's my only point. I just wanted you all to kind of put that in the back of your mind. Also, I talk about all of these issues and concepts in a blog series that I write every week and in a video series that I shoot every week. You can go on the website and learn more and also refresh your recollection as you encounter questions because things are changing in your life, that type of thing. So please remember that. We've created what a lot of our clients feel like is a really powerful resource. All right, so does anyone have any questions at this point? Maybe Cheryl, Cassandra.
Wade, I just wanted to say thank you so much for explaining that. It really makes a lot of sense. And there's a lot of things that you don't think about. And, you know, we all have heard it a couple times, but it helps to reinforce. Make decisions when you're healthy, when you're well, when you can really clearly share what your wishes are. It's really what I refer to like prepare before panic, right? like really spend some time thinking about it. And as you pointed out, you don't have to have this huge estate with, you know, rolling hills to pass on to someone. It's as simple as your personal effects, you know, your gun collection, your vehicle, right? So things that, you know, I think people think they have to have a lot to do this, but it's really just protecting what you have and making sure the folks, when you are gone, making sure the folks get the things you want them to have, right?
Yeah, and the reason all that is important is that it makes it so the client is in control of the situation instead of leaving it to other people when the client cannot take action for themselves. Yeah, that's the big benefit. It's controlling who's going to be the decision maker if you cannot make decisions yourself, and putting in place some guidance for them.
And I liked your idea of like a plan B and even a plan C. So for example, you know, my first choice is my husband, obviously. And, you know, I chose that years ago. So as we both age, I need to think about putting one of my children as a plan B and plan C, right? Because as you said, there could be situations. I really liked that discussion around that long-term care Medicaid. Like that's always confuses me. So I think that's something that I will revisit again on your blog and get familiar. The other thing, Wade, what Cassandra and I can do is we can share your posts every week. We can push them out on our social media so our constituents can have access. We can share, you know, share that out so it'll go to a broader audience through our constituent database.
Oh,
So we're happy
that's
to
a great
do that.
idea, and thank you. Yeah, I didn't even think of that.
We are very happy to do that. Now, specifically, what should your power of attorney contain? So specifically, when you're putting this together, what are some things that you definitely want in that power of attorney? Now, I took notes while you were talking. So your power of attorney is when you're living and it's only in effect while you're living. So what do you want to make sure is in there for if something happens and you're, you know, need someone to step in? What do you want to make sure is like, is there a checklist of what needs to be included?
Yeah, so the power of attorney is only as good as the authority it gives the agent. So there's a lot of different sources of where a person can get the document, and the source of where the document is created is going to dictate the outcome of, does that document cover all of the issues that should be covered? And really, more importantly, is the document that you have in place, is it valid under Delaware law? So one of the sources of, let's just use the power of attorney as an example, is the internet. You can go on there and you can just wear yourself out. There's so many choices of putting in place a form power of attorney. The problem is you have no idea, is that document going to be valid under Delaware law? Did you execute it correctly? etc. The document really should come from an attorney. And well, let me just state this. As someone gets older, the issue of long-term care and how it's going to get paid for becomes more and more important. Now, in the context of someone having a really debilitating brain injury that, they've survived this immediate medical crisis, and now they're going forward living. I mean, long-term care, even for a young person, becomes more and more real. It's an issue that needs to be addressed. So from a long-term care point of view and how it's going to get paid for needs to be addressed in the power of attorney document. And what I'm speaking about really is that you want to give your agent authority to protect whatever assets you have and still have authority to qualify you for long-term care Medicaid or supplemental Social Security, whatever has a financial requirement, so that you don't have to consume all of your assets to qualify. You want to make it so that you can qualify and still have some of your assets on the sidelines to cover out-of-pocket expenses, as you go forward. Once the money's gone, the money's gone. And there's going to be out-of-pocket expenses. So there's two specific pieces of authority that I like to see in the power of attorney. And that is, one, for the agent to have authority to set up an irrevocable trust. Don't get hung up on the technicalities, guys. It's just, you want the document to say it specifically. My agent can set up an irrevocable trust. If the document says my agent can set up a trust, it's limited to a revocable trust. Revocable trusts do not protect assets, only irrevocable trusts do. Now, I go over these distinctions in more detail in my blogs and videos. In addition to authority to set up an irrevocable trust, you want your agent to have authority to transfer assets into this trust. That's how they become protected. When you transfer assets from, when your agent transfers assets from your name into an irrevocable trust, they're making a gift of the assets to the trust. You don't want limitations on how large the gift can be. So it's unrestricted gifting authority.
So it really speaks to, I think, the fact that you're protecting what you have.
Yes.
And it allows you to actually, after this incapacitation has happened, it allows them to make moves to continue to protect your assets without, as you said in the beginning, spending down everything, right? So it makes sense.
Yeah, exactly right. It's just, these are what we call in my business specific pieces of authority, and they need to be stated in detail, very specifically. Authority to set up an irrevocable trust, authority to make unrestricted gifts into the trust.
Yeah.
If it's not there, you have to go to court through the guardianship process to get the authority from the court to do that. Very expensive, really expensive. And it's easy to get in place just by doing the most basic foundational estate plan to get the power of attorney in
Well, I
place.
think
among other things.
the key thing I'm hearing, Wade, is really protecting. So if you really want to protect yourself and protect your assets, protect what you've worked so hard for your whole life, if the unforeseen happens, really you have to make sure that your power of attorney contains these things, and really printing it off on the internet and filling it out isn't always the best idea, right? So really what I'm hearing is make sure that you have an attorney to set these things up for you. So that's why you're living. And then think about, in the event of death, what would you need in place to, again, to protect your assets, to make sure that your wishes were carried out.
Right. Yep. That's a good summary.
Good. So I will open it up for questions. I know we have a couple folks that have joined us during our discussion. So we're happy to, Wade's happy to have a conversation, answer any questions. You can type them in the chat for sure. As we shared, Wade, many of our constituents like to view this in the evening. Some of our professionals are working during the day and they can't always join us live, but we do have a large constituency that that does listen after the fact and weigh in. And I would go ahead, Cassandra, we'll throw it back to you.
The only other question, Wade, I went onto the site. I also, for anybody that's on right now, linked the blog from the website. I also will note the resources tab. Just wanted to know, where are the videos? Are they on the site as well, or is that an external link from the website?
No, they're on the website as well.
I see them. Practice areas / videos. Would that
Yeah.
be the right place?
Yeah.
Awesome. So I will be sure to sum that up in an email and get to everybody that missed this presentation, the 3 key areas on the website, as well as your contact information for anybody to reach out with you. I'm going to ask one more time. Deborah, did you have any questions that you might want to put in the chat? Hey, Ramona, I noticed you joined while we were chatting. Did you also have any questions that you guys wanted to ask Wade? No, everybody's playing shy. All right. Well, Wade, I'd like to thank you so very much. I appreciate you spending time with us today.
Oh, thank you.
The information that you shared was extremely important. I now know that to be quite honest, there's no age limit on getting your stuff together, guys. Let's just get it going.
Yeah.
Call Wade if you have any questions. Power of attorney, seek an attorney.
Yeah.
Okay, let's not play Google with this.
Yeah.
As a follow-up for today's webinar, all participants will receive an email of the replay, the webinar schedule, as well as the links that I mentioned earlier. Please feel free to share this information with your friends, family, and colleagues. Remember to visit the BIAD website, our resource center page, and for additional support. We'd like to invite everybody to join us on Tuesday, May 17th, 2:30, same time, third Wednesday of the month, for our next Educate Delaware webinar. Our guest presenter will be Maggie Kalanick from Defy Therapy Services. Please mark your calendars and plan to join us. Thank you for attending today, and we look forward to seeing you again. Bye, guys.
Thank you.
Thank you,
Thanks,
Wade.
Wade.
Rest of the
Thank
week.
you so much. Thank
All right.
you.
Bye-bye.
Bye-bye.